Good afternoon, everyone, and thank you for joining us today. We're really grateful for the chance to speak with you guys. The topic we've chosen to discuss involves negotiating leases from the perspective of a tenant with limited leverage, either because of the size of the space that they're leasing, the creditworthiness, maybe the lease term, or some rental concessions. We feel that this is an important topic and very practical for in-house attorneys who may negotiate leases somewhat infrequently, and they need to know the high-level issues that will adequately protect the tenant, but also result in a faster and more efficient lease negotiation process. So I hope you guys do find this helpful. Okay, so these are the topics that we're covering today. The first one is just the mindset and the perspective of a tenant with limited leverage. If you approach lease negotiations from the standpoint of a comprehensive lease negotiation, as might be more appropriate for a larger tenant, you might actually end up hurting yourself in the long term, and we'll talk about that a bit later. We're going to talk about the commencement and delivery. So the commencement date and the delivery of the premises obviously are two of the very first things that happen in a lease, and so that's one of those areas you really do want to focus on. The operating expenses is a pocketbook item, right? It's something that we need to really kind of look at. A lot of times you look at leasing and that's the section where your eyes kind of go blurry and you don't really want to think about all of the things and what they mean. But if you hit a few of those things in a really in a strategic way, you'll save yourself money in the future. There's additional operational components of the lease, which Erin will talk more about, but this is really the kind of the nuts and bolts of the legal aspects, but also the practical aspects, because if you think of leases as a significant amount of business as well as legal, that's really the mindset you have coming into a successful lease negotiation, specifically for a low or lower leverage or limited leverage client or tenant rather. And then the last thing is the construction and finish out. So these are very high level issues, but I think it'll help us get to where we need to go when you're not trying to spend hours and hours and hours on a lease, but still protect yourselves. Okay, so again, focus on the presentation is on office lease tenants, but the issues that we're going to be talking about are applicable to all tenants. And in every lease negotiation, you're going to keep your perspective and your situation and your leverage at the front of your mind. It's not always about the size of the tenant. So we really don't talk about small tenants because it's really relative to the space of the size. That's just one component though. There are a lot of other things at play. But a tenant may have limited leverage based on several factors, including, like I said, the rental rate it's paying, the term of the lease. There's just a lot of considerations, or the speed with which you need the lease completed. So there's a number of different factors that go into it. But if you maintain that focus, you're usually more successful in the end. You're focusing on important items. Really, it's financial. That's the main thing. Think about your pocketbook and your operational issues. Because unlike a transaction that involves like the sale of a building or something along those lines, you're usually stuck with a lease for a longer period of time. If it's a 5-year, 7-year, 10-year lease, you really do want to think about the practical aspects of how that's going to play out over that long period of time. So don't lose sight of the situation as you're reviewing the lease, as you're going to likely see many, many different items from a legal perspective that the lawyer in you is going to want to change. But if you are trying to look at this in terms of putting your business hat on as well, most of the time you will end up with better provisions that are more practical, a faster lease negotiation, and then you get your tenant and your business folks in the building faster, and it's a win-win for everyone. One of the other items that's just sort of this probably goes without saying, and many of you know this, there's usually a letter of intent that covers all the important business issues, but not all of them. That's the thing, right? The brokers will tell you it covers everything. It almost never does. And brokers are, as we know, their mindset and their focus is on getting the lease signed. Obviously, that's when they get paid. So I always tell people, be as business minded as you can, but don't rely on brokers to tell you what the actual deal is, because sometimes they've read it and sometimes they haven't. Another big, just kind of bigger picture item is in terms of being overzealous with the lease negotiation. If you really do, you see a provision that's just not drafted in the way that you'd like it, the defined terms are correct, but the wording is off. I tell people when you are looking at it from the perspective of a limited leverage tenant, the more red and blue that's on that red line when you send it back, because you're pretty well always starting with the landlord's form, you tend to create a tone that may not be what you want and may not help your end game. So overzealousness can hurt you. In addition, the landlord will immediately say, oh, this tenant's too difficult. And sometimes you lose out on really important business points that you'd rather have simply because you were trying to wordsmith stuff. It's not that you're wrong in terms of, your drafting would have been better probably than the landlord's short form that they gave you. But the reality is you have to kind of see the forest, you can't see the forest for the trees. And I think that's one of those things that this is a really important aspect of not just being too comprehensive. The other thing I always do when going through a lease is use a checklist. You can create your own checklist, obviously, but another option, use this handout that, if you can print it out and just go through, because we've hit the high level stuff. It's not everything, but I think it would help in terms of, focusing on the bigger picture items as you go through it. Get the next slide. Okay. So here's our first thing. The commencement of the lease determines obviously when you start paying rent. Most of the time sometimes there's a commencement date and then another defined term that's a rent commencement date, but these are the main components where all of a sudden money starts getting involved, right? So it's the first major hurdle that a tenant is going to cross. If something goes wrong, it is typically related to delivery or finish out. We'll talk about finish out a little bit later, but those are the two areas. After you're in the space and you've started paying rent, yes, condemnation or casualty or an indemnity or default, all that can come into play. But where it's the most critical usually is at the very beginning of the lease. And in addition, it sets that long-term landlord-tenant relationship up. So you do really want to consider kind of these topics. The ones we're going to talk about are the triggering events to commencement. We're going to talk about the construction considerations and the delivery deadline. Okay, so like I mentioned, tying down the commencement date's the first big ticket item. And this is, again, where you start paying rent. So it's really important to really focus on this and make sure that you are very cognizant of when this commencement date occurs. You do want the triggering events to make sense for your client. So when I look at the commencement date, I do focus on basically four main areas. The first one is what's on the screen here is a triggering event. Oftentimes, and the reason we titled our presentation the way we did is because if you, sometimes you get a lease that's only like 12, 14 pages, and what's not there is actually what can be critically negative for the tenant because it's just not spoken about. So you'll see these commencement date provisions. They're very bare bones. Again, most of the triggers are silent and they're not adequately addressed to give you a clear definition of the various things that can happen before you should start paying rent. The second thing that I focus on is clearly stating the conditions that trigger that commencement date. They need to be in that section. A lot of times in leases, you'll see that various defined terms some are in exhibits, some are in the body of the lease, some are in the commencement date section. But this is one of the most crucial sections in the entire lease. And so I do really start there. The third issue to really focus on is that the conditions themselves tie to any other applicable provision in the lease. For instance, in your work letter, which we'll talk about in a bit, the work letter is going to talk about the construction. And in that, very often, there's something called substantial completion, which I'm sure many of you are aware of. The substantial completion component, if you negotiate the commencement date section properly, it will tie, but you need to make sure that the definition in one section does make sense in the commencement date section. And we'll talk a little bit about that in a bit, but you do need to double check those defined terms because sometimes they are a bit misleading and they're not really what the business folks had in mind when they were looking at it, and certainly not the brokers. Again, the brokers just think, oh, commencement date or substantially completed, that's probably fine. The fourth component I look at is the time component. Depending on which party is performing construction, and I will say this, on lower leverage tenants, you typically are not performing your own construction. But nevertheless, depending on which party it is that's doing the finish out, the considerations are different from a tenant's perspective. When the tenant's doing it, the concern is addressing lead time. So if the tenant doesn't control all the processes, like for instance, plan approval, let's say that the tenant has a finish out that the landlord has to approve, but there's no deadline for the landlord to approve that plan, it's going to be difficult for the tenant to control all the aspects that it's in charge of in order to meet certain deadlines for the commencement date. And then the last thing you want to be doing is paying rent before something happened that you couldn't control as a tenant. So that's one of the big things that you really do want to look at. On the other hand, when the landlord is constructing the improvements, the concern is on tightly defining the definition of substantial completion, which we'll get into a little bit later when we talk about the work letter. But it's a very important connection between the work letter and the commencement date. And a lot of times it does go overlooked. So this is an example of, we'll give you a couple slides here that show you sample provisions. The first one is a landlord-oriented provision where the tenant's performing the work. Again, it's not as common as the other ones, which we'll talk about in a second, but sometimes I've seen it. If the tenant is performing the work, the commencement date trigger is going to be based, at least in the example here that you can see on the screen, is going to be based on the landlord's estimate of the period of time anticipated for the tenant to complete the work. The problem is the landlord is going to estimate that to be more aggressive than what the tenant probably can achieve. So suddenly you might not finish the tenant work and you're paying rent. And so that's not a result that works. The key is to making sure you build in enough time for the tenant to actually complete construction. And then remember, it's not just the finish out, it's also any fixtures, equipment moving into the premises, all those things have to be, so you really have to start with your end date. This is when project managers are very helpful, and it's critically important to involve them in the process when we talk about the commencement date as well as the finish out. So just bear that in mind, that you almost have to work backwards from your end date and then, build in enough time. Typically, again, this is a sample landlord provision. I would not agree with this at all as being something that you'd want to live with, but it is very common. Again, the variable delays that a tenant can come up against, many of them are not controllable by the tenant, have to be built into the provision. So again, this is a starting point. Let me get to the next one here. Okay, these are some concepts that I like to add. Again, there are much more aggressive positions to take if you have a lot of leverage, but this is more limited to kind of what you would want to end with, or a couple different choices that would both be acceptable. The first one, the first like we talked about, the first concept is if you can't control it, it needs to be built into that language. The second one, force majeure and landlord delays are also something that need to not be on the tenant with respect to if they're, if it's delayed and, if there is a weather event, because that happens, right? You've got to, you can't be paying rent if you can't be in the space. So the next slide here talks about, this is an example of a tenant negotiated lease. I'm going to give you just a second to look at it. I don't expect you to read the whole thing, but I think it might just be helpful if you skim it real quick. So I don't know if you guys are finished yet, but I'll kind of just give you an overview. The key here is that we've reduced the variables that can hold the tenant up. And then we have a trigger date built off of that date. Again, you need to make sure the tenant is paying attention and pushes for a time period that works, because honestly, you don't want to be sliding into home plate when the work is just being finished. It just makes the business guys mad, and you do want to build in cushion, because honestly, with the current state of delays in supply chain issues that are going on, almost every lease we're negotiating right now, the finish out is delayed because you can't get glass or you can't get, various materials. And so you do need to really think that through and build in some cushion. So this is a decent provision for that. Okay, so when the landlord is performing the construction, which is, as I mentioned, more common, the considerations affecting the commencement date are definitely different. So the key trigger here is when the landlord is performing the work, it's basically substantial completion is the magic word, right? But the way that it's defined is important. So you want it to be very tight. One of the things you will see very often when the landlord is performing the work is that the definition of substantial completion in the work letter order will be basically when the landlord's architect certifies that the work is complete. That is, it's very common, but you need to strike it every time, because it cannot be that the landlord's architect is always going to say it's complete because they work for the landlord and I should say they're always going to say it's complete. Maybe you have a few that don't do that, but for the most part, they are going to say it's complete earlier than the tenant thinks it's complete. It really needs to be, you have an approved set of plans. And then when the work is complete in accordance with that approved set of plans, that's when you would be deemed complete. Punch list items, sure, there might be a few little things that, that are still outstanding, but if you've got, paint that needs to be touched up or something along those lines, that's not going to preclude the tenant from doing business in the premises, which is what you want, obviously, to have happen. And the other thing you want to do, if you can, even after substantial completion has occurred, you either build in time for the tenant to complete its fixture work, or you allow the tenant to be in the space with the landlord, as long as the tenant's not, creating a problem or precluding the landlord from finishing the work in a timely manner. But that way you can both be in there, and usually you can make that work. But you just have to build in, you have to tighten this definition up. And again, like I said, if you ever see the language that says when landlord determines it's done, it's done, it's a non-starter. So, okay, so here's some examples of language that when the landlord is performing the work that you will see. Okay, so the first one, again, this is a landlord-oriented provision. Again, this one does not work. We actually had this example in a lease very recently that we negotiated, where you would actually expect this type of language if you were to agree to it at all, which I would still say a couple slides ago, go to one of our secondary choices. But this was when the landlord was completing the work, and if you look at this, a hard date when the landlord controls the work. So that hard date in there would mean February 1st. Tenant would need to start paying rent, but the landlord who's in control of the work may or may not have finished. It's an absurd result that doesn't work for the tenant. But when you look at it at first glance, and maybe a broker's telling you, oh yeah, that's the deal we negotiated in the letter of intent, just be really mindful of the fact of thinking that through. The second one here is an example where a landlord might propose this, maybe even as a fallback position if you don't go for the first one. It's an acceptable option. It's not necessarily the best option, but it's better than the first for sure. It contemplates substantial completion as the trigger. And then again, like we talked about a minute ago, substantial completion being tightly defined will help narrow this. The third right here is a further negotiated provision. You sometimes will get this even as a limited leverage tenant. The key here is that it gives you a little bit of extra time because you're actually fixturing the work as well. So you build in just a little bit of time, 30 days past the delivery and substantial completion. This is one of those areas where I know the business folks often don't want to read a whole lease, and we see leases that are 10 pages long up to recently did one that was 80 pages long. You aren't going to get a business guy more than likely to focus too much on an 80-page lease, and even a 10-page lease possibly. But this is a section they need to look at. They need to make sure it works. So I do require, there's a few things in there where I always, put in bold for my business guys to take a look at. Okay, so in connection with your finish out and starting to pay rent is the delivery deadline. Unfortunately, very often the lease form that the landlord will send to you is going to be silent on the delivery deadline. And if it addresses it at all, it's usually going to say an estimated delivery deadline. that's fine that you have an estimate, but that's not enough. That's just an estimate, right? And there's no obligation for landlord to complete that. So if the landlord fails to meet the deadline, what remedies, if anything, does the tenant have? In the context, the reason this is important is a couple things. If you've got a tenant that is moving from one building to another building, the building they're in may very well have a holdover provision, which means that if you've gotten to the end of the lease term, you're paying maybe 150 or 200% of the rent that you were paying at the end of the lease term. So it's critically important that you think about those two things and they have to move, right? It's not like it's, day one, they're in the new space. So you do really need to consider the timing on these things, which is why it's very important for the business folks to be involved in this process. So you do kind of have to think about the occupational or the operational urgency when negotiating the delivery deadline for the landlord. You probably do want to build in some remedies though. One of the options that I like to build in is saying that, okay, you got your estimated deadline, let's say it is February 1st. And then you give them, because every landlord will tell you, well, I can't guarantee it'll be February 1st. I need some grace period. So you give them 30 days after the estimate to have any of your remedies kick in, where you're both kind of sharing in the risk, if you will. So I think that to the extent that you can say, okay, if you miss it by 30 days or even 60 days, at that point, we get a day for day credit, if you will, or an abatement for each day beyond the missed deadline. And then the other thing you need to, at a minimum, even if you don't get that day for day abatement, because landlords will always tell you they're not in the business of, giving money to tenants or terminating leases. And I do understand that because we do a lot of landlord representation as well. But the reason that I think this one's even more important is that you have an outside termination date. So for the time, let's say you get your day for day abatement or you don't, you can't negotiate that in, that at a minimum, 4 to 6 months after that date has passed and they still have not delivered the premises to you, what you need to have is a termination right. The reason is it's actually very important. I've had this come up a couple of times. If a landlord gets economically distressed and there's a pending foreclosure or something's going on, right, and they're just not doing the work, the tenant has to move on. The tenant's got to find space to be in because they need an office building, or they need office space. So what you really want to make sure of is that ultimately, if you do have to sign a different lease because your landlord's just not delivering the premises, you can't be. But then let's say the landlord becomes no longer distressed and does finish it out. But let's say it's 9-10 months later, but you've already signed another lease in the meantime. You can't be on the hook for 2 leases. That's not a reasonable result. So this is why that outside termination date, if they miss all of the deadlines for delivery, is it really, really important. It's one of those things that doesn't always happen, but because I have seen it happen, I was very grateful that the language was in there that gave us some remedy to move on, because I think, that those results would be highly unfortunate. Okay, so this is an example of what I was just basically mentioning, giving a tenant the right to terminate if landlord fails to deliver within 60 days is what we used here. One of the things to soften it a little bit so that a landlord might be okay with it, it is, subject to force, it is subject to force majeure. I prefer not to do that. But in this, it is something that you might want to do as a lower leverage tenant to make them agree to some sort of outside termination date. It's just kind of the language that's in orange that's italicized there, or at least it's orange on my screen. That's the part that if you can get that, if you can get it out, that's great, but you do have to get the fact that tenant may terminate the lease is the operative part there from the perspective of negotiating on behalf of the tenant. Okay, so the next big item that hits the tenant's pocketbook is operating expenses. If you are representing or if you are working on a lease with a very limited leverage, very small space, they just want to get in and get out, this is actually where I focus the most. It is most landlords are pretty silent on, they want to pass through all of their, pro rata portion of their expenses to tenants, which is reasonable, of course. Almost every lease is like that, or many leases are like that. But what they're silent on is any of the typical savings provisions. And while I would not suggest on a lower leverage lease that you try to put everything on, all of your limitations on operating expenses, I do think it's appropriate, even for tenants with limited leverage, to request some basic protections related to operating expenses. Okay, so what we're going to talk about here is exclusions, caps, gross up qualifications, audits, and outside date for changes or charges. And these are the main 5 that I focus on. All right, so generally operating expenses only include actual and reasonable costs incurred by the landlord in connection with operating and repairing, maintaining the building, that type of thing, management fees, all of that. It is customary, though, to propose a list of exclusions. The thing I would like to say is that you will likely, I have a long form of exclusions and a short form of exclusions, because if you present to a landlord when you're a smaller tenant a long form, you're not going to get it, and you may not get anything. But if you propose a short form, what I find is maybe it's a psychological thing, but the landlord will say, okay, these things, they do make sense. Here's a sample of some scaled back exclusions. You guys can use this to kind of just go by. There's other ones that I didn't include here, but this is a recent one I did. The idea is a reasonable list. It's basically, to the extent that the landlord paid for something that was only for one tenant, it doesn't make sense to pass that through to every tenant on a pro rata basis. If the landlord doesn't pay something that they owe on time and they're assessed a penalty fee, again, that's not reasonable to pass that through. So this list is, I think, a pretty good list to start from, and it's not the whole, it's not 30 things. So I think it's more palatable. Even if you get some exclusions, the key is also to obtaining a cap on those expenses. This is sometimes negotiated up front by the broker. Sometimes it's not. If you don't see it in the LOI, I would encourage you to go ahead and raise the issue to say, did you want any sort of cap on certain expenses? Again, you really need to see what those expenses are. One of the caps could be a 3 to 5%. You see 5% a lot on a year-over-year basis. So that way you just know, you kind of have an idea of what your expenses will be from year to year. The fallback from the landlord's position is if they give you a cap, they'll often say, well, we'll give it to you, but only to the extent that it can be limited to controllable operating expenses. I typically agree to that, because again, if they're willing to give you a cap at all, it is market to have that only based on controllable. Here is an example of a tenant negotiated cap. You want to take a quick look through that. You can see in the orange here, it's limited to 5% per calendar year. And then it talks about what the controllable operating expenses are. This is where the devil's in the details. You do need to look at it that it's anything. If you look at the italicized language there that says within the reasonable control of landlord, we italicize that because if you can remove that, you should. If you can't, landlords will say, well, if I can't control it, but I like to say all expenses other than taxes, insurance, utilities, and sometimes you'll see snow cost removal, depending on where you are. But because basically those are the ones that you're really looking at. And I think that's pretty market. But if you can't get it, you may get a fallback of the landlord saying, well, if it's not within my control, I can't deem that to be a controllable expense and therefore not subject to the cap. But again, this is language that if you can get it, this would be something you may be stuck with. That's not perfect, but it's better than nothing. Okay, so here are some additional protections for tenant on operating expenses. We'll just briefly run through these. First one is a gross up qualification. Second one is audit rights, and third is an operating expense cutoff. So the premise on the gross up qualification is this, and this is sample language that is a tenant negotiated provision. Remember, a landlord is going to have something in the lease that entitles the landlord to gross up expenses that as though the building were almost fully occupied, or sometimes it'll say 95% occupied. Those are expenses like utility cost, things like that you would see, and it makes sense. I'm not going to get into too much of the detail on this, but one of the things you want to make sure of is that the language really in the gross up really should say the costs that do not vary with occupancy, because to the extent they do, they should not be grossed up. If they don't change regardless of the building occupancy, it's important to make that caveat. So I just say, you can see in the language, like third line down, it says they're limited to variable expenses. Just that phrase, variable expenses, is the key part of that. And then to the extent that you say, these expenses, because your property taxes, even if you have 30% occupancy, you're still paying property taxes in most jurisdictions based on, the occupancy doesn't come into play. So these are the things that are inappropriate to gross up, if that makes sense. All right, so here, the next one on additional operating expense protections is audit right language. A tenant should try to negotiate this into the lease. Again, this is just the right to look at their books and make sure they're not passing things through to you that they shouldn't be. My strategy on this provision is, if I can get an audit right as a small tenant, I will accept the landlord's language most of the time, because of the fact that it is, it's going to be watered down. What you see here on the slide is less, it's more what you start with, and then you probably fall back to whatever their language is. What I've learned with landlords is they've got if they're going to give you an audit right, they will give you their language. You're not going to get your language, but this is a good starting point. Okay, and so the last operating expense protection that I like to include when negotiating on behalf of tenants is a requirement that the landlord has to provide us the statement of the operating expenses within 2 years of the date that they were incurred. Or if they don't, the tenant isn't required to pay. This is really more of an accounting issue. But the last thing a tenant wants is for 2 years later, 3 years later, to get a bill from a long time ago. So landlords do often push back on this provision, but it because they will go through their own audit and be like, oh, we undercharged you. But it is reasonable to ask for it as a starting point, and it's not going to derail the negotiation, which is one of the key components of this. So, okay, so I'm going to turn it over to Erin now to talk about other operational issues.
We're going to turn now to issues that tend to come up a little bit later in the life of the lease. And I like to categorize these as operational matters because they can affect the tenant's day-to-day operations in the premises. Certainly, some of these things are tenant-driven. The tenant wants to make changes to the space, or the tenant's undergoing corporate changes that will require an assignment of the lease. Others tend to involve issues beyond the tenant's control, but that do very much impact operations. So things like unavailability of parking, utilities, or other services. And some of these are really beyond the control of both landlord and tenant, like casualty events. So I discuss alterations first because this is an issue that's likely to come up during the lease term, and one that often takes tenants by surprise. So a typical landlord form will prohibit the tenant from making alterations to the premises without landlord's consent. And we all know that the needs of a tenant can change over the term of the lease. So the tenant does need some flexibility to make minor changes to the premises without having to go to the landlord for approval. And many landlords are willing to pre-approve and make exception for a limited scope of alterations. Those exceptions tend to focus on cost and the nature of the work being performed. And then the other issue to think about in the alterations context is, if tenants constructing the initial improvements in the premises, you want to make it clear that the construction of those improvements is governed by the work letter only. Because if there's a conflict between the alterations section and the tenant work letter, the limitations in the alterations provisions can really impair the tenant's ability to finish out the premises in the way that they intended. So you can put this caveat in both the alterations section and the work letter, or in either place. So there can be some tricky limitations in the alteration provisions. And I'll give you an example that came up recently for me. So I was representing a tenant taking a partial floor in an office building, and the alterations provision had this language that prohibited the tenant from changing any decorations that are visible from the exterior of the premises. Well, knowing kind of what the build out was going to look like, we knew that the lobby was probably going to be visible from the elevator bank and other common areas on the floor. So anytime that you have a tenant who might not be taking, an entire floor, think about the fact that there can be limitations in the alteration provision like this, prohibiting decorations without landlord approval, that the tenant doesn't really want to have to go to the landlord every time it makes a change to the decorations in their lobby. So in this instance, we were actually able to remove decorations from items that were within the landlord's sole discretion to approve. And then a lot of landlords are also willing to pre-approve a limited scope of alterations. So this provision hits the most common exceptions. That would be a limitation on the cost of the work, and then also a prohibition on work that affects the building structure or systems. So by limiting the cost of the work, the landlord has some assurance that the changes the tenant's making truly are small, minor changes. And then understandably so, a landlord does want absolute control over anything that affects the building structure or systems. So as long as those two exceptions are in there, landlords are usually open to some modification. And then this final example addresses my comment earlier about clarifying which provisions of the lease would govern tenants' initial improvements. If the tenant's constructing the initial tenant improvements, then you want to make sure that construction and finish out is not subject to the limitations in the alteration provision. And then you'll also want to take a look at other sections of the lease that may conflict with the work letter. I've seen indemnities listed in both, the body of the lease and in the work letter, and I've also seen inconsistent treatment of mechanics lien provisions, both in the body of the lease and then the work letter. So a carve out like this, just something to clarify which provisions govern, is often helpful. So the next issue that tends to come up and that a tenant will want to address are the assignment provisions. The landlord's form lease will usually prohibit the tenant from assigning the lease without the consent of landlord. And very rarely do you see a requirement that the landlord be reasonable in withholding its consent. And you also do not often see any carve outs for common corporate transfers. So there are a few changes any tenant would want to make to the assignment section. So first, I always like to add that the landlord will not unreasonably withhold its consent to a proposed assignment. And then next, if the tenant is aware of any pending or imminent corporate transfers, you'll want to specifically describe those and include them as a permitted assignment. And then in addition to that, just go ahead and include, a standard permitted assignment provision that covers your more common transfers, transfers to affiliates or subsidiaries. And then the last issue I like to look out for with respect to assignments, make sure that the lease doesn't have a landlord recapture right. And if it does, you'll want to add some qualification to that. So some leases will give the landlord the right to terminate the lease and take the premises back if the tenant makes an assignment request. And in that case, you just want to make sure that as the tenant, you have the option to unwind the request if the landlord makes that election. And I've got a few examples of each of these changes. So here's an example of a reasonableness qualifier. The landlord will typically push back on an unlimited reasonableness standard. So as a tenant with limited leverage, it's actually not a bad idea to go ahead and incorporate your standard limitations, because I always find that it's better to propose your own list instead of negotiating from a landlord-friendly list. And then here are some common limitations that I find acceptable from the tenant's perspective. They focus on the things that you would expect, related to credit worthiness, making sure that the tenant, the assignee, is going to operate the premises in the same manner as the initial tenant. So I know there's a lot here, but you guys will have a copy of the materials to refer to if you want to look back at these. And then this is just a standard permitted assignment provision that allows the tenant to assign the lease to affiliates or to an entity that's acquiring the tenant's assets. This is fairly broad, so you might actually get some pushback from the landlord. You know, they may impose some additional conditions related to the assignee's credit worthiness or things of that nature. But I always like to go out the door asking for this one. And then finally, like I said before, if the lease permits the landlord to terminate the lease when tenant makes an assignment request, this provision here gives the tenant the option to take back that request and continue the lease. So moving on to indemnities. So rarely is an indemnity provision drafted any way other than 100% landlord favorable. So there are a couple of ways that you can fix this. So I always like to start with proposing a cross indemnity. And again, this depends on your leverage. If you're on the higher end, then you might be able to start with this. And so a full cross indemnity is really just that. It's truly mutual. You're probably going to get the landlord pushback, but I always like to make the argument that it's just a shifting of the insurance risk. And then the best way to draft this is just by mirroring the tenant's indemnity with whatever changes you have agreed to with the landlord. And then alternatively, you can request what I like to call a limited cross indemnity. This just bifurcates the indemnity based on the location of the event that is giving rise to the claim. And then finally, if landlord is unwilling to give an indemnity, which many of them are, at the very least, you should limit the indemnity to exclude any claims to the extent arising from landlord's gross negligence. So this first provision illustrates a limited cross indemnity, and it just provides the tenant will indemnify the landlord for everything in the premises, since that's the space that the tenant controls, and the landlord will indemnify the tenant for everything in the common areas, because that's the space the landlord controls. But if you're unable to get an indemnity from the landlord, the very least you should accept is this carve out here from tenant's indemnity for any claims or losses that are caused by the landlord's gross negligence or willful misconduct. And again, you guys will have these materials so you can refer back to the sample provisions. Okay, so moving on to something we can all relate to, parking. So the lease, you want to make sure that it provides this for specific parking rights for the tenant's employees, because really the tenant's use of the premises is of little value if its employees have no place to park. The lease should describe specifically the number and location of the parking spaces that the tenant's entitled to use. And then, many landlords have multiple parking locations. They have garage, surface, valet. So make sure that you're clear about what the tenant is getting. And then the lease should address certainly current parking fees, but if the parking fees are subject to change over the term of the lease, you want to make sure that you also have a mechanism in there for how the future parking fees will be determined. And then finally, be very clear about what tenants' remedies are if parking is unavailable. And more than likely, you will see nothing on this point, which again, that's the point of the presentation, is for you guys to kind of have some ideas about things that might just be wholly missing from the lease. So this is a provision that I came across recently. The landlord had proposed that if the parking spaces were unavailable, then the tenant did not have to pay for the parking spaces. And while I found that to be a generous offer that I didn't have to pay for parking spaces that I wasn't going to be able to use, there are a couple of ways that I would suggest modifying this provision. So first, I would definitely strike the provision saying that the abatement of rent would be the tenant's only remedy. And then add a meaningful remedy for the tenant. If the unavailability continues for a specified period of time, either give tenant the right to terminate the lease or make the landlord commit to provide alternative parking at the same rate as the unavailable parking. So for example, if your surface parking is unavailable, then landlord can give you garage parking at the surface parking rate until the surface parking is available. So the period of time really just depends on what's acceptable to the landlord and tenant, but keep in mind the tenant should never have to pay parking rent for any time that the parking is unavailable. And then similar to parking, if tenants prevented from using the premises because of the unavailability of utilities or services, things like elevator service, AC, water, you're going to want some basic protections like abatement of rent. So a landlord's form lease may offer rent abatement, but typically only after a really long period of time. I see upwards of 25 or more days. And I think 2 to 5 days is quite reasonable. And remember, the tenant is paying for these services as part of their operating expenses. So this is a fair request from the tenant's perspective. The only caveat here I would say is that most landlords are going to limit the right to items they can control or for things, interruptions that are not their fault. But again, for a tenant with limited leverage, it's certainly better than nothing. And then moving on to casualty, the possibility of a casualty is certainly remote, but these provisions are key when it happens. So first, if landlord's form does not include, make sure that you are adding a covenant for landlord to insure the building. You want to increase the chances that there will be funds available to repair the damage. And you shouldn't get pushback from the landlord on this request because ultimately the tenant will be paying the cost of insurance through its operating expenses. And then the next thing I will typically do is propose some abatement and termination rights. And most landlords are amenable to that in limited circumstances. So in this first sentence here, this is the first situation in which I will typically request a termination right. So if after you evaluate the casualty damage, it's determined that the damage can't be repaired within a specified period of time, then give the tenant the right to terminate. And 180 days is pretty common, but whatever the tenant proposes really should coincide with your business interruption insurance coverage, because you want to make sure that to the extent you're not also able to negotiate a rent abatement, which I'll talk about it in a couple of slides, you want to make sure that you've got some coverage there. So second, if you don't terminate the lease under that first sentence, but the casualty is not actually repaired within a specified period of time, again, I would typically see somewhere around 180 days, then the tenant should have another right to terminate the lease. Because again, practically speaking, you can only wait so long for the premises to be repaired and get back into your space. And then finally, do take into account the need to abate rent. If you're unable to use the premises, whether in whole or in part, make sure that you abate the rent to the extent and for so long as you're unable to use the premises. And these last few sentences on this slide address your rent abatement. And then the last operational issue is one that we don't really like to talk about, and that's default. I would say at the beginning of the lease, we all engage in a little bit of wishful thinking and say, oh, well, this is never going to come up. But there are two changes that even a tenant with minimal leverage can request, and that is cure periods for both monetary and non-monetary defaults. So the landlord will often push back on a cure period for the payment of rent, but you can usually get them to agree if you add this language that's highlighted here in orange. So that's a reasonable request. You just add a notice and cure, but limit it to say 2 times in a 12-month period. This helps the tenant, but it also gives the landlord some comfort that if the tenant's truly having financial difficulties, the landlord will not have to provide notice to tenant over and over again. And so that, like I said, this here is something that I often will get, will often get landlords to agree to. And then for monetary defaults, ask for extra time if the default cannot be cured during the stipulated cure period, but the tenant's actually pursuing the cure. So typically, the landlord's going to ask for an absolute outside date, like you see here, 45 days. Obviously, avoid that if you can, but again, something is better than nothing, and getting that little bit of extra time may make the difference for you. So that's it for the operational related matters. We obviously don't have enough time to cover every possible scenario, but these are common issues to keep an eye out for. I'm going to turn it back over to Ashley to finish up with a brief discussion on construction issues.
Okay, so construction issues, I'm going to run through this really quick. Like I said about the commencement date, it's actually one of the most important things. Consider reviewing it first. It's one of those, it's one of the things usually in an exhibit. but it's so critically important because it's such an easy way for people to get kind of crosswise. So I do typically say, go ahead and review that early, and maybe first. And then we'll also talk briefly about the tenant allowance. I'm not going to get in the weeds on this too much. It's very driven by what the circumstances are. But do keep just keep in mind that the location of it, people think it's an exhibit. They don't really want to look at it. It's one of the most important parts of the lease. Make sure your business folks also look at it, because the business teams really need to understand, especially your project manager, and they all have to kind of agree to how this is going to go. The timeframes are incredibly important, not only like we talked about the holdover on the existing lease, but also just getting into the space, and especially if the tenant is performing certain parts of the work or maybe all of the work, you have to have the timeframes, especially anything tenant can't control, really nailed down. Otherwise, it's gonna you won't make your deadlines. One of the more important things is evaluating the provisions in the work letter compared to the provisions in the lease itself. You sometimes will see inconsistencies there. We've seen them several times. So you do, obviously to the extent, like Erin mentioned, alterations need to be covered very clearly by the work letter and not by the alteration section. But in addition, look at insurance, mechanics liens, indemnification, all of that, compare them to the lease, because very often the landlord will slap an exhibit on the back of the lease that doesn't have any connection to the similar provisions in the lease. So to the extent that ever comes up and there's a mechanics lien or indemnity, you don't want conflicting things, because your insurance folks will bless maybe the insurance provision in the lease, maybe didn't look at the work letter. So just be sure all the business folks, insurance consultants are all on board with that. Okay, so with respect to tenant allowance, these are some of the things you often see come up. This is just typical of limited leverage tenants and their leases. Most of the time, landlord is performing the work, and it's up to, and I say up to in quotes, up to a certain tenant allowance. Anything in addition to that, the tenant's usually responsible for. The problem with some of this is, what controls does the tenant have to make sure they're not caught off guard with surprises and really excessive amounts in addition, to the tenant allowance. So what I would suggest focusing on is limiting the surprises and the delays. Those are the things. It's cost and time. So in terms of the tenant allowance, these are the ways I think that you could, big picture, and every work letter is different, but you'd have to kind of look and kind of see what it says. But obtaining multiple bids for the work, meaning the landlord has to go out and obtain multiple bids, is a great way of doing it. Another option is to determine in advance who the general contractor will be. And that's also a way to kind of just know that the tenant feels comfortable with what's going on from a cost standpoint. The one provision that I think you definitely need to build in is the idea that to the extent that the work exceeds the allowance, you would need, as a tenant, an approval process where you would say yes or no, rather than them just going ahead and all of a sudden just blowing the budget and having your business guys really, upset with you. So that's one of the main things. And then also a punch list and a walkthrough at the end of the lease is also very important, so you get what you thought you were getting. So those are kind of the main things. There's a lot more on the work letter. Like I said, review it first, review it in detail with your business folks. It's truly one of the most important things. Too many people, I think, believe that it's either all legal or all business. It's a completely hybrid exhibit that needs to be really focused on. You have to think through all the issues as it compares to the lease as well. But the business folks must pay attention. And again, if it's an 80-page lease, if you can get them to really read that whole document, and that'll be, 5 to 10 pages, it's well worth your time and will save you from headaches in the future. So in conclusion, each lease transaction is very different, right? So you've got to approach it based on what you've got. But again, the point of kind of what we've talked about today is that it's not just because it's short doesn't mean it's correct. And it means usually if it's super short, it doesn't benefit the tenant. So you really do have to kind of focus on that. And then use this presentation to the extent that you feel it's useful to you as a checklist, but have a checklist of some variety, whether you use this one and add to it. That would be a great way to handle it. And then, when in doubt, do consult a real estate attorney. I think many people come to the conclusion that they can handle the lease. It's not that hard. There are, if they don't see anything glaring that's a mistake or something that they really, really don't like, they assume it's fine. The problem with it is when you have those gaps in the document, those gaps very rarely benefit a tenant and can be very detrimental. So it is really important that you get, the right advice on certainly bigger leases, but even smaller leases. So I know we're out of time. Really appreciate everyone participating and joining us today. If you do have questions, let us know, but I know I'm a little over. So if our emails are up here, we'd love to field questions and just let us know.